Hello everyone, welcome to the session 9 of the subject Procurement and Contract Law. In this session, we will be discussing on the importance of a contract and the law associated and what are the best practices when putting a contract into place in a procurement negotiation. During a procurement negotiation, there will be so many points and areas that will be discussed, argued, negotiated, and agreed between the two respective parties, meaning the purchasing organization and the potential supplier. So all these points that have been agreed between the two parties needs to be included in a formal contract. This particular contract needs to be in line with the country's legal framework. It is very important that this contract being very comprehensive, because when the operation starts or the supplier starts delivering the goods or services, down the line if there are any issues, then both parties can refer to the contract on what has been agreed and find solutions based on those information within those contracts. So during the next few slides, we will discuss what are the important areas and points that needs to be considered when a contract will be developed. The first part would be formation of a contract. So, in order to contract to be legally binding or legally valid, there are four important components that needs to be fulfilled. And those four components will be an offer, an acceptance, a consideration, and an intention. So, first there should be an offer from a party to another, and then the other party should accept that particular offer. During this offer and acceptance, there will be consideration from both parties in order to sell or buy something, and there will be an intention to enter into an agreement. So these are the four pillars or important four components that is required for a contract. We need to understand that all these four components must be present. It's compulsory for a contract to be legally binding and to be enforceable. An absence of at least one component means that there will be no contract. Let's take an example. One organization wants to sell one of their products to another party. So there is a seller and there is a buyer. The seller is the one who comes and gives an offer. The seller has an intention to sell and make profits. On the other side, the buyer can consider the offer and the benefits that they will get from this offer and accept. So take a scenario if the respective buying organization does not accept what is on the offer completely, then there is no contract. Now, let's try to understand what do you mean by an offer from a legal perspective. So, an offer can be defined as a clear statement of the terms on which one party, meaning the offerer, is prepared to do business with another party, meaning the offeree. So, there are few terminologies when you discuss about this offer, and there will be always an offerer, the one who makes the promise, who wants to provide or offer something to another party. And the offeree would be the person or the organization who will receive the promise, meaning the buying organization. Then apart from these two terminologies, there are two other important terminologies, which are, one is the claimant the party claiming for a remedy in a particular court, and there will be a defendant, meaning the party against whom court proceedings are brought in. So we need to get familiarized on these terminologies when we are entering into a contract and to understand each other's responsibilities well. As we have discussed before, the offer will be the first step towards entering into a formal business contract. Any offer will have three basic components or requirements. So in order to have a valid offer, these three requirements are very important. Now, let's see what these three requirements are. The first one would be the terms and conditions which are stated in the offer should be very clear and specific. The second one would be the offer should have an intention to do a business. And the third and the last one would be this respective offer should be communicated to the offeree. So what do you mean by a clearly stated terms? Now, when an offer is made by a seller, there are certain terms and conditions which are included in this offer. And these terms and conditions should be very clear and specific and should not be vague. Because if you include a vague statement, the buyer might understand that statement in a different way, which will result in a confusion. So the seller should be focusing on including very clear, specific and precise statements in their offer so that there will be no confusions in the engagement stage. Just look at the example I have stated on this slide. The buyer of a horse promised to pay the seller an extra £5 if the horse is lucky. The question would be, lucky in what way? The statement is too vague and cannot be enforceable when it comes to a legal framework. When an offer is made by a seller, the seller should have an intention to do a business. So when the offer is made, the seller has to make sure that he has gone through his internal considerations in detail, and the offer will be sort of a last word prior to an acceptance by the buying party. In case if the original statement in the offer is not valid, then there will be no acceptance or no contract. Take an example where a seller comes and offers something to a potential buyer. The buyer goes into details of this offer and comes back and negotiates few points. After a negotiation, then when both parties come to an agreement, the revised terms should be included in the revised offer. So the intention of the seller would be to sell something which is in the revised offer. Whatever that was mentioned in the initial offer will not be an acceptance and will not be considered for a contract. Then moving on, the third requirement of a basic offer would be communication to the offeree. So this particular offer should be formally communicated to the offeree, who needs to acknowledge and accept it. If there is no acceptance from the offeree, then again there will be no formal contract. This communication can be in written form, could be spoken, or by conduct. I am pretty sure that as project managers, you have gone through this contract formation process in the past. And I will not be surprised that if you have come in or come across situations where you have gone through so many confusing statements during a contract formation. So when you talk about these confusing statements in a very formal way, there are two types of statements which may confuse with a legally binding offer. And those two types would be invitations to trade and then statements during negotiation. Let's see what these two types really means. So what do you really mean by invitation to trade? It is something, or it's an invitation from a party to another party to come and buy something or purchase something from them. So these are things such as advertisements, goods in a shop window on display within that shop, or could be catalogs, price lists, menus, etc. So these are things that are merely inviting potential customers to come and make an offer. So the customer will see the products or services which are there for sale, and they might come and make an offer. So the seller is inviting the respective customer to come and make an offer. But it is up to the seller to decide whether to accept that offer or not. If they decide not to accept the offer, then it will be rejected and no engagement or no contract. Buyers will have no rights to the goods or the services until there is an acceptance from the seller. So this will work on the other way as well, meaning there could be a seller who could come to the customer and say, look here, we have something to sell to you all. But until the buyer has accepted, there will be no contract. So whatever activities, or it could be even displays that a particular seller or sometimes even a buyer could do in order to invite the other party to a discussion could be an invitation to trade. Every engagement or transaction will have some sort of a negotiation. So before entering into a contract, there will be lengthy negotiations and discussions between the respective two parties, meaning the buyer and the seller. What we need to understand is there could be so many things that could be negotiated during the discussion process, and whatever that has been offered originally will unlikely to be valid at the end of the negotiation. So during negotiation, there could be so many points that could be unclear to both parties, meaning the seller would come and offer something. In that offer, there could be some terms and conditions which are not clear to the respective buyer. So the buyer can discuss on these points to make themselves comfortable, and they can bring in counter arguments as well, and those counter arguments should be clarified by the respective sellers, and then only both these parties should come to an agreement. And after they come to an agreement only, there would be a formal acceptance which can move on to a formal engagement and a contract. So statements that are made during a negotiation sometimes could be confusing, but both parties needs to ensure that when they come to an agreement, all these confusing statements should be clarified so that going forward there will be no more confusions and concerns. It is very important to understand how an offer would get terminated. It is essential that all respective parties understand when an offer has come to an end so that they are able to move on to their other or new contracts without any concerns or fear of legal actions resulting from their previous dealings. So, how will these offers will be terminated? There are so many ways that it can be done. The first one would be the death of an offeree or an offerer if the offer requires any personal performance. But an offer may survive if it can be performed by that respective person's representatives. As an example, a seller comes to sell something to a buyer and there will be an offer, and during the discussion, if the seller expires or dies, then that offer will be terminated. But if there are other representatives from the seller's side, then those representatives can continue the discussions. The same concept would be applied to the offeree as well. If the offeree dies or expires, the offer will be terminated. But if there are any representatives from the offeree's side to continue the discussions, then the negotiation, the discussions will continue. The second way would be by accepting the offer. By accepting the offer, by saying, yes, I will purchase. The third way of terminating an offer would be through a rejection. So the seller wants to offer something and the buyer is not interested and the buyer rejects, saying no thank you, and then the offer is terminated. Another way of terminating an offer would be presenting a counteroffer, meaning an attempt to vary the terms of the agreement. So the seller will come and offer something and the buyer is not interested in the offer fully. So the buyer could provide or present a counteroffer. When the counteroffer is made by the buyer, the original offer which has been made by the seller will get terminated and a discussion will happen, and then based on the discussion the seller will have to offer a revised proposal or a revised offer, I would say. So just look at the example. Wrench offered to sell his farm for £1,000. Hyde offered, meaning Count offered, £950, but after a few days said he would pay the full price. He heard nothing from the defendant. So after offering something as a count offer, then the buyer has come back and said, no, I will pay the original amount. So in that scenario, the original offer was valid, because even though the buyer has provided a count offer, then he reversed back on his decision and was willing to pay the original price of the offer. The other way of terminating an offer would be the lapse of time, meaning any offer will have a validity period because it has to be accepted within a reasonable time, and if not, then the seller could provide a revised offer. See at this example in this slide. There was a person who applied to buy some shares. So he has applied in June but has not heard anything until November. And in November he was informed that he can have the shares. But he has changed his mind because he applied in June and there was no feedback from the respective organization, and they are coming back only in November and saying yes, he can buy those shares. but by that time the person have changed his mind and the respective shares does not mean anything for him at that moment of time. So there should be a time validity for any offer, and during this time period the buyer should get back to the respective seller so that the offer will be valid. If not, it will be terminated. The last and the final way of terminating an offer would be through a revocation. Revocation is something where the offer that has been already made by an offerer will be withdrawn by him before it has been accepted by an offeree. Just look at the example that I have quoted in this slide. Dodds offered to sell his property to Dickinson but sold it to a third party before Dickinson replied. A friend told Dickinson of the sale. So in this situation, if Dickinson decides to sue Dodds for selling his property, meaning Dodds' property, to a third party while there was an ongoing offer, the law will be supporting Dodds, simply being the respective offer has not been accepted by Dickinson so far. So, in a revocation scenario, the seller has the right to withdraw whatever offers that he has made so far until the offeree has accepted the same. Now, so that we have discussed so much on this topic offer, let's try to understand who will be a reasonable person to get engaged in these offer discussions. As per the law, only adults can get involved in these discussions from a legal perspective. So other than contracts for necessaries and beneficial contracts of service with minors, all other legally binding contracts should be between adults. Because the law takes the view that adults are capable of deciding when and what terms they want to do business, and that those adults, they are capable of making informed and sensible decisions and conclusions. So in summary, if there is an offer by an offerer and there is an acceptance by an offeree, this discussion should be happening between two adults. If this discussion has happened between two minors, that discussion or agreement will not be accepted by the country's legal framework.